Judges are human beings, and they make decisions based on their personal biases and experiences, right, and feelings and moods. But an AI judge will take all of this information, distill it, and objectively apply the law and say, you win. Why shouldn't we be comfortable with that kind of technology that's going to revolutionize the practice of law? We're here today with Deja Lifshitz, and we're going to talk about everything, all of the secrets to
law.
The government's not perfect, right?
What?
People sue the government thinking, oh, I'm going to get access to all this money. That's just not the case. Representing a private party is very different from representing a government. Does their case have merit? Did we actually make a mistake? What will this look like if I have a similar case in the future? Those little nuances of preservation and potential legal errors might go over your head.
That's one of the hardest parts of our job.
There has been an increase in litigation for malpractice against lawyers. There's an aspect of that is cover your ass work. So a judge that can determine the case, you feed it all of the information, all of the arguments, the best that you can do, and then a dispassionate, objective judge, which is really what we hope for in a judge.
AI is going to be the future, and people need to get on board.
Okay, so welcome back to Courtside. We're here today with Deja Lifshitz, one of our colleagues, and we're going to talk about everything, all of the secrets to
law.
To law. She's going to tell us
exactly
everything we need to know. Deja, tell us a little bit about yourself.
Hi, good afternoon. So I started my career doing a couple of clerkships. I clerked the 4th DCA for Judge May. I then went on to do a clerkship at the 11th Circuit for Judge Fay. After that, I went to the county attorney's office, where I was there for 9 years before joining Mark Fair and Hayden.
Nice.
So how do you go from clerking for a federal court judge to public practice? Because usually the route that people take is to go into private practice, work for a ginormous firm right after an internship like that or a clerkship like that, right?
Right.
What was your calculus?
So, public service was something that was always important to me. I felt it was important to give back to the community. And so I got a taste of that through my clerkships, and I wanted to continue that, doing my service at the county.
And you were at the county, you said, for 9 years?
Yep, about 9 years.
What kinds of cases did you work on at the county?
I worked on federal civil rights defense, defending the county and law enforcement officers. I worked on property tax disputes on some of the county's largest properties, multi-million-dollar properties, defending the county's assessment of those properties. I handled a couple of torts cases, some slip and falls, and yeah.
As somebody that has worked in private practice now for, 15, 16, 17 years or so, I'm always interested in that transition from the public sector to the private sector and some of the advantages and disadvantages of coming from the public sector and moving into the private sector. So talk to me a little bit about that. Like, what did you see as some of the unique advantages that you brought to the table because you came from the public sector? And then we'll move on to the disadvantages, if any.
So, first of all, representing a private party is very different from representing a governmental entity. When you have a private client, this may be their first time being sued, or maybe not their first time, but it's a rarer occurrence than at the government. Because of that, they have a narrow focus. It's win or settle and move on with their life. With the government, they're sued all the time. And so you're not looking at it as a one-off lawsuit I need to win or resolve. You're looking at it in the grander scheme of things. You're looking at it more as a portfolio of cases, because what you don't want to have happen is you don't want to resolve a case and open up a floodgate of litigation of copycat lawsuits.
Right.
So when you are analyzing how you're going to litigate, you have to consider, what will this look like if I have a similar case in the future? You have to consider, if I resolve this case, is this going to bring more people out of the woodwork looking for a similar result? But you also have to consider public perception. Your clients are political figures. And so you need to be able to defend your strategy and your result to the public, who really are the ones that hold your clients accountable.
Yeah. I mean, it seems to me that my experience working with government lawyers is that a lot of the attorneys there are really sort of like lawyers, right? In other words, like they're really people that are technically very, very proficient. And there's a part of them that just truly enjoys the study and practice of law. And that's why I think the county attorney's office in particular has some of the best attorneys in Miami-Dade County, period. I mean, including in private practice. I think that some of the best lawyers around come out of the Miami-Dade County attorney's office.
100%. I think there is something to be said for that institutional knowledge that you get by having lawyers who are working for the same client for 20, 30 years, understanding what strategies have worked in the past and what haven't, knowing inside and out how their client operates, and knowing what's going to stand up against public scrutiny in the press.
Yeah. I mean, I would say probably 30% of my job is acting as a therapist to my clients, right? I mean, and you don't have, when you're in the county attorney's office, you don't have a client that you need to play therapist to.
That's correct.
And, for better or for worse. So that's probably one of the skills that, is probably you're still in the process of, not that you're not a great therapist, I'm sure, but that's one of those skills that, is a little different, right? It's a little different.
100%. Yeah. And at the government level, you are looking at the legal strategies more closely than you are looking at catering to people's feelings.
Yeah.
That's 100% true.
I'm curious. There's a statistic that's thrown around all the time, and I think it's partly true and partly lore at this point, but in civil cases, 99% of lawsuits that are filed are settled. That's what we hear all the time. Is that also true for government entities?
I don't think so. And I think that, look, government's not perfect. Right?
What? Well, no, okay. Don't use that. No, everything's great. You're doing a great job, Mr. President.
Look over here.
Okay, sorry.
Look, I can only speak from my personal experience. I can't speak to governments that I haven't worked for. But I think, by and large, the people that are doing the decision making in local government are really trying to reach the right result. Sometimes mistakes happen. Sometimes bad facts happen. But at the end of the day, they're willing to be held accountable in the court if they make a mistake, or they'll resolve it. But a lot of people also sue the government looking for a quick payout. And because of that, settlements are scrutinized a little more closely. And like I said, they have to think about, what does this precedence, what is the precedent that we're setting here for future cases and potential copycat lawsuits to try to get a quick payout?
So you tried a lot more cases, is what essentially you're saying.
The government does try a lot more cases.
And is there ever I'm always curious about this because we do a lot of litigation against the government now. Is there any emotional component? Again, a lot of the calculus in our cases when you're dealing with private clients, whether they're individuals or institutions, is there's often some kind of an emotional component, right? There's somebody who's just like, you know what? Like, I understand that there's risk. I understand that I might lose. I understand these other things, but somebody needs to be taught a lesson. Some variation of that is not uncommon in our discussions with clients. Does that exist at all on the government level? Is there ever a time where somebody or some county attorney or government attorney says, you know what? Like, we want to teach this guy a lesson. We need to stick it to this person. Does that ever come up?
So government litigators are litigators, even though they represent the government. So if there are bad facts that are going to play poorly with a jury, that definitely goes into consideration, just like it would with a private party. I wouldn't say that the government takes a particular plaintiff, for example, and says, we need to teach this guy a lesson. You have your frequent flyers, and of course, you're not going to settle with them because they're coming out of the woodwork with cases that don't have any merit.
Right.
I do think at the government level, it comes down to merit. Mm-hmm. Does their case have merit? Did we actually make a mistake here that we need to make right? And if they did make a mistake, something needs to be made right, the government's willing to do that.
Do you think that going into a courtroom saying that you represent the government gives you an advantage in a case before the facts even reach the judges or finer facts ears?
I think that goes back to the institutional knowledge and the fact that you're representing an entity that is in court all the time, right? government lawyers are in front of these judges day in and day out. You build credibility with these judges. And for that reason, you have to be very careful about the positions that you're taking. You don't want to take a position that's not defensible because that judge is probably going to be on one of your cases in the future, and you don't want to go in losing that credibility from the start.
Yeah.
But from my experience, the governments or lawyers are very, very good about making sure that their defenses can hold water. And because of that, they do hold a certain credibility and gravitas going into the courtroom.
Yeah.
Yeah, I think, one of the things that I'm a little bit jealous about, if we're honest, is when I go into federal court and I'm waiting for my case to be called and you have these prosecutors that are there and they have this rapport with the judge because they're always there.
Yeah.
And no matter how often or how many cases you have in federal court, you're never going to have that because a federal prosecutor has that constant stream of cases are always in front of those judges. So you really do develop that rapport. And I think that goes to what you were saying, right? I mean, the familiarity with that judge, they know you, they know that you're not going to BS them. They know that you're going to be credible. That's huge.
And I also do think that there's an inherent gravitas. Well, there used to be an inherent gravitas with getting up in front of a courtroom and saying, I represent the United States. I represent the United States.
Yeah.
Yeah. No comment on whether or not that.
No, that's still the case. It's still very much the case. That's pretty impressive. Whether you're representing the county, whether you're representing the state, or whether you're representing the federal government.
Yeah. No, look, I think it's. I've always found that government lawyers, people who used to work for the government, really bring a unique skill set because there is so much value in having somebody who's able to dispassionately really analyze a case, and based on the significant experience that you have sitting in front of these judges, you can say like where you think the chips are going to fall. I think that for me as an attorney who has for the most part represented private litigants, it's very hard to not sometimes let my own inherent biases get in the way.
But I think that's true whether you're a government litigator or not. I mean, I've gone to trial with Deja. I can tell you she's not dispassionate.
No, yeah, right. Right. I didn't
she's
mean
very
right. I just been on the analysis side.
Man,
Yeah, no, that's true. Yeah. No, that's true. Right. I mean, you guys did you guys had a great experience at trial.
Yeah, you want to talk a little bit about that trial?
Sure.
See what I mean?
It's amazing. Just I gave you this prop, I called you completely passionate, and you're like, yeah, whatever.
Well, I mean, look, I think, Deja, one of the things that I know that clients do look to you for is providing this kind of like appellate style sort of analysis, right? Like sort of zooming out on a case and saying, okay, how do we set this up for the best possible way if there is going to be some kind of a future appeal? Can you talk a little bit about that world that you play in?
Yeah. So because I started my career in two different appellate courts.
Right. So it's the 4th District Court of Appeal, which is so if you have a trial in, let's say, Broward County, and then and you appeal that up to the court above Broward County is going to be the 4th District Court of Appeal.
Correct.
Okay.
Correct.
And then the other one's the 11th Circuit, which is the federal equivalent for South Florida.
Correct.
Yeah.
So because I started my career clerking for two appellate judges, it shaped the way I think about cases. Looking at a case from an appellate perspective is very different from looking at a case from a trial perspective. Mm-hmm. When you are in front of a jury, you're thinking about persuasion. You're thinking about my tone. You're thinking about how is this playing with my particular jury. You're thinking about how can I use body language and credibility to persuade a group of peers. When you're thinking about cases at an appellate level, you need to think almost the opposite. How will this read to someone who wasn't there, who can't see your presence, who can't read your body language, who can't assess your credibility on a cold piece of paper? And so when people bring me into a case, it's for a couple of reasons. First, they have a complex legal issue that they want a very good substantive motion drafted for. That may resolve the case. If it doesn't resolve the case and it goes to trial, they want someone there who can focus on preservation issues. Because when you're trying a case, you're focused on that presence, you're focused on that persuasion aspect, and a lot of times those little nuances of preservation and potential legal errors might go over your head. So it's really beneficial, particularly in a case with high exposure, to have an appellate attorney sitting with you at trial, flagging those potential landmines for you, sometimes they don't listen to my advice, and that's fine because they're thinking about the momentum of how the trial is going. They're thinking about, if I object now, how is the jury going to perceive that? But my role is to make sure that you know that this is a potential legal issue that you want to preserve, and the trial lawyer can make the decision whether or not they want to preserve that issue or whether it's going to take away from their presentation to the jury.
Yeah, one of the most frustrating, I love trial work. I love going to trial. I love convincing people. I love making arguments. I love standing up there and being the center of attention. I mean, it's awesome. But there are so many little pitfalls.
Yeah.
If you don't object at the right time, if you don't say the right things at the right time, then you waive an appeal. I mean, so there's always somebody as part of my trial team that's going to handle that aspect. That's going to say, hey, by the way, you should be preserving this objection because you're in the heat of the moment and you're doing it, right? And that's critical. That's a critical part of the team. Somebody that can call you out and say, make sure you object now. Make sure you bring this issue up. Make sure that you're preserving, whatever argument you have on this jury instruction. Huge.
Yeah. And there really are not a lot of litigators that have that sort of flex capacity, right? Where they're able to say, who have the experience of that sort of eagle-eyed appellate view, while at the same time that's able to try a case, and I think that's an incredibly unique skill set.
And even as someone who has done both, who has tried cases and has worked as the appellate attorney on the trial, you can't do both. Not to 100%.
Right.
So when Jose...
Which one do you like better?
Ooh.
They both have their advantages.
Oh, what a cop-out.
What a lawyer answer.
This is why lawyers get a bad rap.
That was terrible.
Right.
You gotta like one
Well,
better.
let me make a pros and cons chart and
Look, being the trial lawyer has a glory to it, right? You're the center of attention.
You're the gladiator.
Right. Being the appellate lawyer, you're not in the spotlight. It takes a little bit of pressure off of you from that perspective, but you have to be laser focused on everything that's happening around you. They're different.
Yeah.
And when Jose and I went to trial, I said, look, if I'm going to be second chair, I can't also be the appellate counsel. I will do my best to flag the issues if they come up. But because you're so focused on the persuasion and being concerned about, is the jury looking at me going like this to Jose? You can't do it all.
right.
And so that's why it's so important that if you are going to trial on a case of high exposure in particular, that you have somebody that can sit behind you and flag these issues for you.
There's an old movie called A Few Good Men to that point, and Tom Cruise
It's
right
not that
before.
old. It's not that old, man.
What's so
You're
funny?
really aging me now.
6 years ago, I was giving a talk to a bunch of young attorneys in my former law firm, and I made a comment. I said, "You can't handle the truth,"
Right.
and they were like,
They're like,
"What are you talking about?" I said,
Boomer.
and I said it again, like I doubled down. You can't handle the truth, and they're like,
You're like, come on.
they hadn't seen it. They hadn't
Nicholson,
seen one of the
anybody?
greatest lawyer movies,
What a
in
shame.
my humble opinion.
It is one of the best.
Is A Few Good Men. But anyway, to the point about the jury looking at you and perceiving little things, there's a whole line by Tom Cruise right before he's getting ready to go to trial, and he's telling his team, "I don't want you passing
Who's
crazy."
Tom Cruise? No.
Yeah, exactly. He says, "I don't want you passing notes. I don't want you whispering. I don't want you doing any of these things because the jury picks up on all of those little things."
Yeah.
To that point, right? I mean, that's a crucial aspect of trial work,
100%.
right?
Can I just wanted, I'm sorry, I have to go on this tangent about feeling old. Have you seen the movie City Slickers? I know you have.
Yeah,
Have you
of
seen the
course.
movie City Slickers? Oh, God. It's a classic movie, okay? Classic
may
Billy
have,
Crystal.
but I don't
It's a
remember.
great movie, okay? I highly recommend. Anyway, so the premise of City Slickers is a bunch of guys who go out from New York City and they go to like a dude ranch out west. And it's like this whole journey. And what triggers this need is they just feel very old and they're going through like a significant midlife-ish crisis. Do you know how old they were? Do you know what the age was at which triggered this significant midlife crisis?
What's that?
39.
My God.
And I remember watching that movie and being like, those dudes are old. I
I
remember when
wonder
I
if
was a
I'm going to
kid.
feel that way when I'm 39.
Right, exactly. You got a few years still to go. All right, sorry.
I'm about to turn 39, so
There you go. It's
maybe I'm about to have my midlife
to be in my
crisis.
30s. To be in my 30s. All right. I think having that appellate perspective is incredibly important. I hear you on the challenges between playing both of those roles simultaneously. If you were advising your first chair lawyer and you had an opportunity to maybe get something close to a kill shot with a jury versus something that is going to be more important to preserve on appeal, which way do you lean on that? Because here's the thing, right? Not every case gets appealed, right? A lot of the times you win a case and maybe there were errors made, maybe there were mistakes that were made, but if you win that case, the other side is going to have a strategic decision to make as to whether or not to appeal that case, right? It's not like everything gets appealed. So where do you land on this?
I hate to give you a lawyer answer. It depends. There is no.
I know. It does.
There is no bright line rule on that because you really have to feel how the case is going in the moment. Like, do you think you're going to win regardless of whether you make that objection? Have you built enough credibility with the jury that if you object now and slow your momentum, they won't care? If it's been a rough trial and you've had to object a lot because the other side is pulling some shenanigans and you think this may just be the nail in the coffin, maybe better not to object. Right. Because you maybe have other issues you can appeal on at that point if you lose. There is no bright line answer, unfortunately. But I'll tell you what the
problem is. There has been an increase in litigation for malpractice against lawyers. Okay. So there's an aspect of that isn't just jury work or appellate work. Right. There's an aspect of that is cover your ass work, because it's very easy after the fact, with the benefit of hindsight, to look at something in the heat of the moment in this battle that is trial and say, you didn't object here and you didn't object here and you didn't object here. And you might be able to say, look, I had this momentum. I didn't want to ruin it. I thought the other guy was going to make a mistake. Those are perfectly reasonable reasons why you wouldn't do or preserve some sort of appellate argument. But you have to do it. Yeah. You have to do it to limit those situations. Right. We had a trial in a few months ago, and opposing counsel did it to an extreme. But everything was objection, and he knew he was pissing off the judge. He probably knew he was pissing off the jury, although I don't know because he was a little bit out of it. But he kept on objecting to try to preserve issues and bringing things up that the court had already ruled, to the point where the judge said, you don't have to, it's already preserved. Stop doing it. You don't have to do it. And his point was, well, I don't want to take any chances. Why is he doing that? Because he's afraid. He's afraid that he's going to miss something, and then he becomes a target for a disgruntled client if that client loses. Yeah. That's the unfortunate truth.
And it's this idea again of this sort of difference between what's going on in real time and what is this going to read like on paper down the road. Because this objection concept, it's the same problem, right? Which is that there's so much judgment that comes into being a lawyer, right? And this is actually can kind of also dovetail into some of our AI discussions, right? AI is going to tell you, object to everything. Yeah. Right?
That's a safe bet.
Right? In other words, what AI would say if there was an AI lawyer in there is that the AI would do it by the book at every point. And it's not going to be able to, probably anytime soon, but maybe sooner than we think, read the sort of micro expressions of the jury and the judge, and to know, like, wait, is this the right strategic move here to play this card at this time? Yeah. So that's one of the hardest parts of our job. And then you're right. I mean, about this notion of malpractice and clients coming, and saying, well, hold on a second. Why didn't you do this? Why didn't you do that? It's like, well, dude, you know why I did it. But yes, on paper, 3 years later, looking at this transcript, it's a different conversation.
Yeah, then you got to justify it. Yeah, exactly. On a cold record. So, single most memorable moment in court that you've ever had?
Oh, single most memorable moment I've ever had in court.
Commit.
Probably my first trial in federal court. I was cross-examining an expert. The night before, I was reviewing all the records again, and I noticed a particular record that I thought, I don't think he factored this into his opinion. I confronted him. I prepared for whether he had an answer to it and if he hadn't reviewed it. And when I confronted him with it, he said, no, I didn't see that record. It wasn't given to me by counsel. And I asked him, and isn't it true that this would impact your opinion had you read it? And he said, yes, it would have. And then he looked at his lawyer that had hired him and went,
oh, God.
Oh, wonderful. And at that point, you sit down.
Yep. I said, no more questions.
You leave that alone. Yeah, exactly. I'd say you don't ask anything else.
That was my first trial in federal court, and probably one of the most memorable and exciting moments I've had in a courtroom.
And that was for the county?
That was for the county. That was a civil rights defense case. We were defending for corrections officers who had been sued for excessive force.
I was really fishing for a compliment, to be honest with you. That's like a really thoughtful, but I was just going
I'm
to
so
say,
sorry.
Right.
My trial with Jose was the most exciting moment of my entire
there you go.
career.
Let's make sure we get that on film. That's the answer.
That's funny. All right. So tell me also a little bit now about what you see. I want to talk a little bit about the future of law from your standpoint. Okay. I know this is where I'm going on.
You're going off script.
I'm going rogue. Okay. So what do you think being a lawyer is going to look like in 10 years from now?
I mean, I don't even think you need to go that far, 5 years from now.
I mean, think about it. I don't think I had even heard of ChatGPT a year ago.
Right.
And now everybody uses some sort of AI in their daily life.
Yeah.
You know, whether it's personal questions, health questions, you know, helping frame an email, you know, everybody's using AI. 5 years from now, who knows what that could look like? I've heard some pretty interesting developments coming in the legal AI space. Like you were saying before, who knows if AI will be able to read those micro expressions on jurors' faces? That is currently being developed, that there would be a camera, if a judge allowed it, to monitor jurors' facial expressions when you are presenting a particular argument or a witness and give you real-time feedback in the middle of trial. That's something that's unheard of at this point, but I think is not that far off.
Yeah.
But going back to your point before, there is a human element to what we do that AI will never be able to replicate.
Yeah.
There's a feeling between people, you know, reading facial expressions. Maybe AI will be able to read facial expressions from a scientific perspective, but I don't think that translates into the real world. So what will the future of law look like? Probably a lot of AI.
Yeah.
AI is going to be the future and people need to get on board. But I don't think it's going to replace us, at least not anytime soon, probably not in our lifetime.
Fingers crossed. But you know, there is some real momentum for things like AI judges, right? So a judge that can determine the case, you feed it all of the information, all of the arguments, the best that you can do, and then a dispassionate, objective judge, which is really what we hope for in a judge, but we don't get that because judges are human beings, and they make decisions based on their personal biases and experiences, right? And feelings and moods. But an AI judge that'll take all of this information, distill it, and objectively apply the law and say, you win. Now, that sounds crazy in a formal trial setting, right? There aren't going to be, in my experience, any AI judges sitting on a bench anytime soon. But I do think that that's going to be happening more in arbitration. Just yesterday, I got an article about that, about, you know, just kind of saying in your arbitration agreement, just like you say, we agree to have our disputes resolved by arbitration, saying, and by the way, it's going to be some sort of chatbot or AI judge or some sort of software that's going to make that determination. Think about it.
You know, I wouldn't be surprised if in the next year or so you start seeing in contracts, rather than there being a dispute resolution process that says, you know, arbitration or jams or whatever, that you see a dispute resolution process that says, you know, Claude.
Yeah.
Which says, you know, and there, I could see a scenario where you sort of lay that out, where you say, okay, every side, and you could lay out the exact process, right? Every side gets to upload, you know, 20 documents, right? Every side gets to upload a 5-page brief, the actual, you know, 10 or 15 cases that they're relying on, dump it into Claude, and let Claude make the decision.
Yeah. And you could put whatever parameters you want to, just like when you're drafting an arbitration provision, you can say, yeah, don't award damages beyond whatever it is, $5 million, or, you know, don't award this kind of relief.
Right.
I mean, I do think that that is a real possibility. I think we're going to see that sooner than 5 years from now. We're going to see that really, really soon.
Yeah.
Would you consent to that?
I mean, as a lawyer, I would always give the kind of response that you give, which is like a hedge. But in reality, if you're a business owner, right, and you want a quick resolution and you don't want to spend 2 years or 3 years arbitrating an issue, and you don't want to spend hundreds of thousands, if not millions of dollars, I would consider that. I would consider it. You know, I would want to put some safeguards in place so that if, you know, the system went completely rogue and came up with something that was just outrageous, I'd be able to have some sort of recourse, some sort of appellate recourse. But in terms of just kind of surrendering the decision to a chatbot, I would be comfortable with that. You know, 2 years ago, if you had talked to people about automated automobiles, right? They would say, are you crazy? I remember I had a couple of partners that had just bought Teslas and they had the autopilot feature on it and they were uncomfortable using it because it was novel technology. On my way to today's studio here, I came across 3 different Waymos in Miami, which by the way, a month ago, they were not here. So that's just technology. And people are comfortable getting into those cars and being transported by those cars in the same way. Why shouldn't we be comfortable with that kind of technology? That's going to revolutionize the practice of law. It really is.
I think it's because people think that they can tell their story in a more persuasive way than a robot could interpret that story.
Yes.
Okay. Like, in other words, I think there is such a strong bias for people to think that if only they had an opportunity to tell their story as a human, to tell their story, that is the opportunity that they need to prevail, because everybody always thinks they're right. I mean, I heard a stat that said, and I don't know if this is obsolete, but years ago, I heard a statistic that said that 80% of people think that they should win their case. Okay, well, it's 50-50, right? But 80% of the time people think they should win their case. So when you know that you should win your case, or when you feel that you should win your case most of the time, you would never want to run the risk of letting an AI determine whether or not you should win, because you feel that you could tell the story in a way that's going to prevail because you're right, because the facts are right. And by the way, you have the better lawyer, and and all the other things that are associated with that. So I think there's some very human hurdles to where people are going to get comfortable with that. Unlike, for example, auto drive or things like that, which I think it's a little bit of a different,
No, I think so. I think we get there. I mean, as a lawyer, I can tell you that I prefer, if I have an emotionally charged case, right? Maybe the law isn't as strong on my case, but the facts are really, really good, right? I want a jury. I want to be able to tell that jury, because I think I can do a better job of telling that story than a dry record. Yeah. Right. I can convince that jury. I could talk to them. I could look at them in their eyes. I could speak to them. I could get my clients to cry a little bit on the stand. That's just the reality. That's what happens.
I think this goes back to what you were saying before about lawyers are part-time therapists as well for their clients. And some clients just want to be heard. Some clients need that cathartic experience of getting on the stand and telling a jury of their peers, here's why I was wronged. Even if the jury doesn't come back and award them anything, sometimes they just need to be heard. And I think giving that decision to AI would remove that, that moment for certain clients.
That's true too.
It would dehumanize it, right?
Yeah.
I agree with that.
Yeah, that's a good point.
So turning back to your appellate practice, single biggest issue that trial lawyers fail to preserve for appeal.
You're going to hate my answer, because there is there's no single failure to preserve that comes up over and over. Because if it came up over and over, people would remember not to do it. They would remember, here's the landmine I need to preserve. I think it comes up because they're so focused on what they're supposed to be focused on, which is the jury. And some things just aren't on their radar because they're so focused on, here's a great point that this witness made. I need to remember that. I need to prepare my closing argument. They're so focused on the trial, as they should be, that they either don't catch the issue that needs to be preserved, or they make the strategic decision not to object to it, even if they catch it. There's no one particular area. One area I would recommend trial lawyers brush up on if they don't have an appellate lawyer present is brush up on the case law around jury selection. Because a lot of lawyers understand the rules of evidence if they're a trial lawyer. Jury selection, I think, has a lot of pitfalls that people could face, and either hire someone like me that can help guide you through the process, or do some research ahead of time before you go into jury selection to remember what all the pitfalls could be.
Jury selection is such an important thing because each judge, even within the same courthouse, has different rules. Okay. I tend to talk a little bit about the facts of the case without prejudging it, to just see if there are any biases, right? So if we're trying a case about business partners and one of them is alleged to have stolen money, I will say that this is a case in which we allege that the defendant stole a bunch of money. Based on those facts, does anybody have a problem? Right? Some judges will allow that. Some judges will allow you to go further. And some other judges say that's pre-trying your case, right? You can tell them this is a business dispute between business partners, and based on those facts, does anybody have a problem? But that's as far as you can go. So I think that's to your point, I think that that's a really, really important aspect of the case that you have to be mindful about. I try to push it as far as I possibly can within the bounds of ethics and within the bounds of the court's rules, but you have to be mindful of that. But I will give you what I think is the biggest mistake that trial lawyers forget to concentrate on for appeal. And that is jury instructions, right? Jury instructions. I can't tell you how many lawyers I've dealt with on the other side that they just go very routinely about crafting their jury instructions. This is the standard instruction and you kind of go with it. You got to remember that the jury instruction is something that gets taken by the jury back into that deliberation room. And when they're being asked to determine whether it's a breach of contract or unjust enrichment or whatever the claim might be, they look at that catalog. They look at those instructions. They look at how it's drafted. So if you're not mindful about how it's drafted, number one, then you have a problem. And if you don't get the version of the jury instructions that you wanted, not only do you have to object at the time, but when they're being given, again, otherwise you waive it, which is remarkable, right? I mean, can you talk a little bit about that?
100%. People overlook the importance of the jury instructions. They usually think of it as, this painstaking task that they need to do. And they wait till the last minute when the judge is like, I need the jury instructions right now.
Yeah.
They'll slap something together and forget that it's the one thing that the jury takes back into the jury room that you have written. Everything else they're taking back into the jury room was out of your control.
Right. You don't even get to talk to them during the trial. Right.
The jury instructions are the one thing that you have control over that they can take back into the courtroom. You can run into some serious issues if you don't have legally correct jury instructions, run into reversible error there. But also, you want to make sure that the jury instructions make sense. If you just go by the standard instructions, a lot of times they might not capture the essence of what the jury really needs to decide. So although they're there, they're not binding. A lot of people think the standard jury instructions are binding. They're not. You can propose your own jury instruction on a particular issue. And often, you should craft your own jury instruction. There are sections, even in the standard instructions, that you have control over. For example, the summary of the case, the summary of the claims. How you frame those is important.
Right.
The jury is taking that back into the jury room, and it's probably going to be one of the first things that they read when they're trying to decide your case. So if you blow off preparing your jury instructions and slap them together last minute, you're really running the risk of tanking your case.
Yeah, that's the first mistake. And the second one is not objecting.
Correct. The judge is not always going to go along with what you want for a jury instruction.
Right.
Even if it's a warranted instruction, you need to preserve your record on that. You need to object. You need to explain to the judge why he's wrong. And you need to object again after the instruction is given in order to preserve that for your appeal. Because if you're right and the instruction that they've given is wrong, you may end up having a great appellate issue.
Right.
So, Deja, let me ask you this. We do obviously a lot of work where we represent business owners that are in some kind of litigation with the government, right? For whatever reason, we seem to attract a lot of that kind of work. What would be one takeaway or one sort of piece of advice that you would give a business owner who's in
Go ahead.
who's in litigation against the government, based on sort of your experience at the county? What are some pearls of wisdom that you can offer?
It's tough to take off that government lawyer hat, isn't it?
I mean, I could tell you, so I can riff a little bit about my experience on this because, again, not that I have the same insider's perspective that you do, but certainly we've done a lot of litigation adverse to the government. I mean, number one is I think that lawyers tend to underestimate the quality of. I think the private lawyers tend to underestimate the quality of the lawyers in the government. Mm-hmm. I think that's something that I see a lot, and I never ever underestimate those folks. They're usually like I said before, very good lawyers. Usually the government lawyers also know the statutes really well because they've litigated the same issue 100 times. So for me, one of the advantages that we've worked where we've got you, obviously, you're a former county attorney. We have another attorney in our office who also is a former county attorney. from Broward County. And the expertise that you all bring to the table, where you have that sort of deep insight about these particular statutes and how those statutes work, it's just not something that private practitioners come across all that much. So I think that that's another very good advantage that you bring to the table. So I would say know the interplay of the statutes is probably another, is something significant. But anything else that comes to mind for you?
The government is not going to fight you without justification, I think is an important thing to remember. A lot of people, when the government does something that they don't like, tend to assign bad motive to that governmental decision. I think a lot of people get that wrong. In my experience, the people making decisions at the government level are trying to get it right. Do they always get it right? No. Mistakes are made. Sometimes the outcome isn't what you expect. But I think trying to assign improper motive or buy into some sort of conspiracy theory from the beginning can really cloud your judgment about the strength of your case against the government, and can also really cloud the legal issues that are going to guide the decision in your case. Government lawyers don't want to litigate a case that they don't have to either. So I think having a lawyer on your side that can work well with the lawyer on the government side, try to reach a resolution that makes sense for both parties, is your best bet. But also remember, the government is not, a bottomless pit of money. People sue the government thinking, oh, I'm going to get access to all this money. That's just not the case. Their decisions on settlement have to be justifiable to the public, and over a certain threshold, they have to be voted on by government officials who have been elected and have to fulfill promises to their constituents. So, you have to go into it with a mindset of, the government's not out to get me, even if it feels like it. This isn't going to be a blank check. And there's probably a resolution here, but maybe not to the level that I'm expecting.
Right. No, that's good advice.
What's one case from your county attorney's days that still guides the way you practice today?
It's not one case.
Oh, God.
It's a journey.
It's a journey. It's all about the journey.
It's all the cases collectively.
It's an intricate tapestry of cases.
So my time at the government, I wouldn't say guides my practice today because of the cases that I was doing. Okay. It's about the people that I was working with. I was fortunate to have some great mentors at the county. On one hand, I had a great mentor who is an incredible trial lawyer, incredible person. Yeah. He knew how to read a jury. He knew how to read a judge. And he taught me the presence of presenting a case. On the other hand, I had another mentor who tends to practice mostly in federal court, and she taught me that preparation, clean record, great briefing can win the case before you even step into the courtroom. Right. So it's not about the work that I did at the county, it's the mentors that I had there. And I think that's so important for young lawyers to understand, is that you need to have that mentor. No matter what kind of work you're doing, you need to have somebody who can show you the ropes, who can show you how to be a good lawyer, because that translates no matter what type of law you're doing.
If you had to do it over again, would you follow the same career path?
I would. I enjoyed my time at the county. I enjoyed my clerkships greatly. I think I learned a lot. Mm-hmm. And I'm really excited to be learning, a new area with both of you.
Well, we're very happy to have you and excited to have you.
There's on that
earthquake. On the note of the apocalypse, I think it's no, but thank you, Deja. Thanks for coming on. It's always great to hang with you.